My name is Jeff Morgan. I'm from Dallas, Texas. I've got a lot of things to talk about today, particularly with the case of the Save James trial case. This case was heard in the 255th District Court in Dallas, Texas, in front of Judge Kim Cooks from October the 15th through the 21st, 2019. And this was in the interest of Georgialess versus Younger. The case number is DF-15-09887. So there's a lot that I want to talk about in this. I've kind of held off until I actually had something in my hand in writing that was official, at least semi-official. This is not the official final order yet, but this is the order that as I understand it, was read by Judge Kim Cooks on the day that I was barred from the courtroom. I and other people that were there throughout the duration of the trial because we did not have media credentials. And even though one of the individuals who did a lot to expose this whole thing and to report on it had media credentials, she too was forbidden from entering the courtroom. So whether there was retaliation against certain people because of them making it widespread and known to the public, I really can't speak to, but I do have my own suspicions regarding that. So to read the order, it says this. On April the 6th, 2018, the mother filed a petition to modify the parent-child relationship and filed an amended petition to modify the parent-child relationship on July the 2nd, 2018. The father filed for a counter petition requesting to be the sole managing conservator on May the 7th, 2018. The case was set for final trial by jury for October 15th through the 17th, 2019. On October the 21st, 2019, the jury rendered its verdict on 11 jurors. The jurors answered the following two questions, and these were the two questions posed to the jurors. Question number one was, should the current joint managing conservator be replaced by sole managing conservatorship of James and Jude Younger? The answer was yes. Now, I'm not even sure if all these jurors knew exactly what was entailed and the difference between a joint managing conservator and a sole managing conservator. Nevertheless, 11 out of the 12 of those said yes. Question number two. Should Jeffrey Damon Younger, and this was the father, be appointed as sole managing conservator of James and Jude Younger? The answer was no. This shocked many of us who were there. After having heard the testimony, it should have been a no-brainer. If there was going to be a sole managing conservator, it should have been the father, not the mother. That was my opinion. I came to that conclusion very early in the trial by listening to the testimony. I was surprised that 11 out of the 12 jurors made the decision the way that they did. And in fact, the decision was so egregiously bad that even the judge herself overrode their jury verdict. So it would appear anyway, based on this order. The court finds that there has been a substantial change in such circumstances with a child or parent that warrant a modification. A modification, by the way, if you get a divorce, if you get an annulment, your days in court are not necessarily done. These modifications can last for years and years and years. I know of a person who's in his 15th year of going through a modification. 15 years later, he is still fighting in the courts. Hundreds and thousands of dollars. Modifications never cease. Divorce or annulment or something like that, they are the lawsuit that keeps on giving. So once again, this is a modification of that was in front of the court. I don't know exactly what the costs of this case were, but my guess is that it cost both parents well into the six figures, if not individually, at least collectively. Based on the testimony and evidence, the court makes the following findings and rulings as being in the best interest of the children. Now, before I go into what she writes about the best interest of the children, I first would like to say that, number one, nobody even knows what the best interest of the children is. The so-called best interest of the child, or the best interest of the children, has been an evolving doctrine that has been taking place over the last years. What it may have been at one time is no longer substantiated by what we know from research. The best interest of the children is something that is nebulous at best. It is an opinion. It is can be wrong. There's no way to prove that what you are saying is in the best interest of the child or the children. So here is a judge who is somehow rendering an opinion on the best interest of the children based on what she has heard in testimony and in her court. And by the way, not all of the full testimony was heard. This is something, if you go to a court looking for truth, you're not going to get truth, you're going to get a story. An attorney wants to tell a story. An attorney for the plaintiff or the petitioner wants to tell a story. story, to convince the jury that his or her client is in the right and should be awarded certain things. So what it will do, it will shut down truth that will be damaging to that client's interest. The same thing would happen in the case of a defendant. So for example, if I were speeding and I got pulled over for speeding, and I said, then they asked me if I was speeding, and if I said yes, I was speeding, and this was the reason why, if I had to speed up to avoid an accident. If I started to say that I had to speed up to avoid an accident, the attorney would say objection, non-responsive. They just want a yes or a no. So even though yes, I was speeding, there was a very legitimate reason for speeding. Had I not been speeding, I could have caused an accident. Somebody could have been killed, but the attorney will shut me down from saying that. If I have an attorney that's good, they will probably let me speak further to that when he or she comes and examines me. But nevertheless, what happens is that if you're looking for truth in a courtroom, you're not going to find it. You're going to find a story. So when you raise your hand to swear the truth, the whole truth, at best you can say, I do swear to tell the truth. Whether I get to tell the whole truth is going to be dependent upon the attorneys. It's going to be dependent upon if the judge will let me speak. So once again, this judge heard part of the truth, and based on part of the truth that she heard, she has determined what is in the best. She is going to make the following findings and rulings as being in the best interest of the children. The court finds it was presented by the petitioner mother. So once again, the mother was the one who brought forth this lawsuit. It was the mother. The father was responding to the lawsuit. The petitioner to the lawsuit was the mother, with the request as to whether the court should, number one, enjoin the father from cutting the hair of the children. So the big thing is, I want the children's fathers to stop cutting their hair. This is what the lawsuit was all about. This is what takes place in your Texas family courts. Judge, I need to have a lawsuit to find out whether the father can be forbidden from cutting the children's hair. This is what the lawsuit was about. And this is a finding of fact concluded by Judge Kim Cooks. So it's legitimate. The lawsuit was about whether the father should be permitted to cut the children's hair. Number two, she wanted orders entered requiring the father to affirm Luna and honor her choices both inside and outside the home. Now, as I've mentioned previously, Luna is a fake name. It's a fictitious name. It is a name found by the mother and her daughters on the internet. And it was given to James. James is the boy's legal name. He is a biological male. He has XY chromosome. At the very chromosomal level, he is a boy. That's a fact. It's a medical fact. It's a biological fact. His legal name is James. And yet here she is in court requiring the father to affirm Luna. Now, who is Luna anyway? Luna is a made-up name for a fictional person who supposedly is a girl who does not exist, except in the mother's mind. But she is in the courtroom requesting an order requiring the father to affirm Luna and her choices. A boy goes by the male pronoun him and he and his. A girl goes by she and her and hers. James is a boy, not a girl. But nevertheless, this is part of the matter appearing in family court in the state of Texas. Number three, enjoin non-affirming behavior and or taking Luna outside the home as James or allowing others to do so. So here is the mother's case. The mother wants the father to not take James, who is a biological boy, James, which is the boy's legal name, wants an order from the court requiring the father not to be allowed to take James outside the home unless he affirms him as Luna. Number four, this again, remember, this is in your Texas family court. This is a very big, important issue that we need to have a judge decide on. It's going to cost well over $100,000, but the judge needs to decide on this. We need to modify the father's possession on school nights when there are school-related activities that may occur during the father's possession. And the reason that Miss Georgelis, the pediatrician, Miss Ann Georgelis, Dr. Ann Georgelis, wanted this entered into an order is because Mr. Younger took his son, James, to the school as a boy, where she has had him enrolled as a girl with the name Luna. Now, the father knows that the boy is a boy. The father knows that his legal name is James. So again, these first four things are all designed by the mother to try to maintain this fiction regarding James, this delusion that she is putting upon James. Number five, the father should be enjoined or forbidden from condemning the mother for saying Luna, or from the father hanging up when he hears the name Luna during electronic communications. So what was taking place when the father, Mr. Younger, was talking with James on FaceTime or whatever it may be, the mother would sometimes say, Luna. And that's when Mr. Younger would hang up. He did not want that affirmed. His son, James, is a boy whose legal name is James. The mother has this idea in her mind that somehow the boy is really a girl or wants to be a girl or should be called the girl's name, should be dressed as a girl, should be enrolled in school as a girl, should have lipstick put on him at times, should be made to wear dresses, whatever it may be. This is what the mother wants, and the mother wants to make sure that the father is not allowed to hang up on James during FaceTime. And again, this is in your Texas family courts today in the state of Texas. Number 6. She wants the father to be enjoined from signing the child up for activities or taking, and this is the quote, taking her as James. Now again, he is a boy, biological boy. Nothing has changed. This was not some type of a situation where he was born a boy and lo and behold, bam, all of his chromosomes changed from XY to XX. He is a boy. He is a biological medical boy. And a doctor should know this. A pediatrician should know this. But somehow in pediatrician, Dr. Ann Georgelis's mind, something has happened that he is now a she, and she wants to make sure that the dad is not allowed to take James to sign up the child for activities under the name James, or calling her, again, this made-up pronoun, James, at any activities. Number 7, enjoining the father from allowing the children to remain in the presence of anyone who is not calling the child Luna or using the pronoun her and affirming Luna. So I have never met James and Jude. I had the opportunity to do so, but I chose not to because I wanted to make sure that it would not appear that I would somehow be tainted by actually having met them in person. So I've never met James and Jude. I have seen pictures of them. I've talked with the father. I have not talked with the mother. I'll be very happy to talk with the mother, but I don't think the mother really wants to talk with me. If she does, she can very easily contact me. I'd be happy to talk with the mother about this whole thing. So I've not been tainted by meeting James and Jude, and I've not said, according to my opinion, James is a boy, which my opinion is really irrelevant on the matter. He is a boy. It's a fact. The fact is he's a boy, and his legal name is James. But the mother wants the father to be enjoined from allowing the children to remain in the presence of anyone who calls James anything other than Luna, and who refers to him as him rather than her. So had I met James and had I said, hi James, how are you doing today? And if I use the pronoun he or his or him, the father would have to forbid me. The father would have to take the child from my presence because I was calling James by the name James and using a male pronoun with him. So as far as I can tell, these 7 reasons were the reasons that the mother filed the lawsuit against the father. The mother was not seeking to become the sole managing conservator. She felt that the father did have an important role in the child's life, but she wanted to be in control over what he was allowed to do, what he was allowed to say, and she also wanted to limit his time with the children, and basically also make the father accept the whole transgender ideology, which goes against the father's personal convictions, against all facts, against his religious convictions, but she wanted to have this imposed upon him by the court. By Judge Kim Cooks, this is what the mother was seeking to do. The court finds that the mother made no request to be appointed as a sole managing conservator, as I mentioned. The court also found that the mother made no request to surgically or chemically transition the child's sex or chemically castrate the child. Well, that was not in discussion yet. She was preparing him for that with a social affirmation. So it's not surprised that there was no request to surgically or chemically transition the child's sex or chemically castrate the child. The court found that on October the 18th, 2019, at approximately 9:56 a.m., Day 4 of the jury trial, it was brought to the attention of the court by the mother's attorneys that the mother's affirmative pleadings were her responsive pleadings filed October 2nd, 2019, labeled Ann Georgelis's answer to counter petition to modify in suit affecting parent-child relationship. Mother states that she is asking for the court to implement what is recommended by Dr. L. Britton. Now, Dr. Benjamin Britton I will talk about later on in another video. I would love to have seen his report. I do not have access to it. I would love to see it. If Dr. Benjamin J. L. Britton would love to send me the report, I'd love to read it and evaluate it on my own, give it in my independent scrutiny. But I'm sure that won't happen, and I'm certainly not capable of reading a report like this. The court disagreed that a responsive pleading replaces the affirmative pleadings filed by the mother on July the 2nd, 2018. Therefore, the court's ruling addresses all live pleadings to which the court heard testimony and evidence. And I'll continue my observations, my commentary, and what I saw at this hearing and what the judge ruled on in upcoming videos. Thank you.